Well, good morning, everybody. Good to see you. Thanks for being here. You have logged on to Grand Rounds presented by the Department of Psychiatry and Behavioral Sciences. But of course, you already knew that. What don't you know? Well, I should introduce myself. My name is Jed Thompson. I'm the Associate Director of Communications for the department, and I'm the host of Grand Rounds. So, we've got a great presentation for you here today. Dr. Michael Compton is joining us, but before we get to his introduction, I want to go over some of the nuts and bolts of our grand rounds. We're going to cover some of this for those of you who are joining us for the first time and while we're waiting for others to get logged on. So, couple logistics for you. We record all of our grand rounds presentations. So this is being recorded right now. Soon we'll have this uploaded to our archive on YouTube. And if you want to watch it again, you can. Or you can watch any one of our grand rounds going all the way back to 2010. So we've got a huge archive out there for you to check out. We have a survey also. If you want to give us any feedback after the presentation, if you get our Grand Rounds emails, there's a link in there for the survey. You'll also see it as soon as this webinar closes. Right when the screen goes blank, there'll be a link there to our survey. If you want to provide any feedback for us, we'd love to hear it. In terms of Q&A, we're going to hopefully have about 10 minutes or so at the end of today's presentation. So if you have any questions, anything you think of throughout the presentation, go ahead, type that into the Q&A, and then we'll have those all queued up and we'll have those ready to go at the end of the presentation. So don't be shy with those. And then if you're available next Friday, we'll have another good presentation. That's September 26th, and we'll have Jeff Deskalakis will be joining us from UC San Diego. So please plan to be here next Friday. All right, what else can I tell you? Let's actually go to the next slide here. And before we begin, I want to let you know that today's presentation is part of our Ripley Memorial Lecture Series. So this is dedicated in memory of our first department chair, Dr. Herbert S. Ripley. He began as the chair in the 1940s and remained so for 20 years. So keep him in mind while we're learning about today's presenter. And to do that, I'm going to toss it over to our current chair, Dr. Jürgen Unitzer, and Jürgen is going to tell or introduce today's speakers. So, Jürgen, the Zoom screen is yours now.
All right. Well, thank you, Jed. Good afternoon, everybody. Welcome to Psychiatry and Behavioral Sciences Grand Rounds. And so today I have the pleasure of introducing our speaker, Dr. Michael Compton. And before he speaks, I will tell you a little bit about him. Dr. Compton is professor of psychiatry at Columbia University, but he didn't start there. He was born and raised in Virginia. He got his undergraduate degree in religion and biology from Mary Washington College and his medical degree at the University of Virginia. He then moved south to Emory, where he trained in psychiatry. He trained in preventive medicine, in public health, and in community psychiatry. And during his time at Emory, he served as an inpatient attending at Grady Memorial, and he worked at a community mental health center doing some of the very early work in first episode psychosis care. In 2010, he moved to George Washington University, where he was professor and director of research initiative. And from there, he moved to Manhattan, where he served as chair of psychiatry at Lenox Hill Hospital. And then in 2016, he joined Columbia University, where he works today. Dr. Compton is a distinguished fellow of the American Psychiatric Association, a fellow of the American College of Preventive Medicine, and his research really works at this, focuses on, this interface of health and public health. It focuses specifically on criminal justice involvement among persons with mental illness. A topic that we have become increasingly interested in here as well. He has broad interests beyond that on the social determinants of mental health. He has interests and experience with food and nutrition insecurity, and he has a special interest in farming, in healthy eating, and in lifestyle medicine. And I'm not sure he can share all of that with us today, but I wanted to tell you just a little bit about what a cool kind of broadly interested and experienced guy he is. Today, we've asked Dr. Compton to talk with us about challenges and opportunities in how we care for individuals at the interface of mental health and law enforcement. And with that, welcome, Dr. Compton.
Thank you so much, Jurgen. It's a real delight to be with all of you. Even though there's great distance between us, I think that this topic is actually one that's shared, on the East Coast and the West Coast. And so I'm really delighted to share some of my research with you. The research that I'm going to be talking about was supported by these funding streams: the National Science Foundation, along with 4 different R01s. I'll briefly mention findings from 3 of those and go into a little more detail related to the first R01 that's shown here. Also an R34, and more recently, the Pew Charitable Trusts and the Sozose Foundation. Here are some learning objectives for this afternoon. I want you to be able to list some common misdemeanors that our patients with serious mental illnesses are arrested for. I'm going to go into detail about the CIT model, which is based in law enforcement agencies. And then I'm hopefully going to be able to explain the ways in which arrests might be reduced through mental health approaches, as well as reforms and crisis response. And I'll sort of have 3 broad topics this afternoon. I'm going to explain the problem. I'm going to present 4 different research pathways and then share some of my current research interests. So the problem that my research is attempting to address is really what we call criminalization of people with serious mental illnesses. This is their overrepresentation in all facets of the legal system. There are many, many underpinning causes of criminalization. For example, there aren't enough accessible community mental health services that people really want to engage in. We know about the problem of deinstitutionalization and thus transinstitutionalization, which is thought to be a key driver of criminalization, but also the fact that crisis response for so many years has involved 911 and the police. Some illness characteristics themselves likely increase the risk for criminalization, and also the high comorbidity of substance use related disorder issues, and the fact that many of our patients are psychosocially disadvantaged. And so some of the arrests that I'm going to be talking about really are related to poverty, social disadvantage, housing instability, homelessness, etc., as much as they are related to the mental illness itself. And I also want us to keep in mind that the overrepresentation of both individuals with SMI and people of color across all levels of the criminal legal system is really in large part the result of social and economic forces, the so-called social determinants of health, as well as systemic racism. And on the other hand, criminal legal contact itself is a social determinant of mental health. We know that people who become entangled in the misdemeanor criminal justice system have poorer mental health outcomes. So, criminalization is driven both by the social determinants and is a social determinant itself. I'm going to be focusing primarily on people with serious mental illnesses. We know that they have heightened vulnerability and stress during police encounters that can escalate the situation, especially if police officers don't understand what's going on. Many people with SMI have a history of prior negative experiences with the police, and that changes how they relate to police officers the next time and the next time. We know that criminal legal system involvement amplifies their stigma already in a stigmatized group. And we know that once people with SMI enter the system, the criminal legal system, they're more likely to stay longer in jail, under court supervision, on probation, etc. There's also quite a bit of research on the experiences of law enforcement officers They feel that mental health response, including crisis response, should not be a core job function. But often it is, in many, if not most jurisdictions, it is part of their core job function. They feel that they receive too little training and they want more training. They feel that they have too few tools and they want more tools beyond just the options of making an arrest and or transporting to the hospital. They view our system, the mental health system, as deficient, with inadequate follow-up and inadequate support for family members. I want to briefly mention the sequential intercept model. This is a model that lays out the various phases of criminal legal system involvement to help us think through where there might be off-ramps for our patients with serious mental illnesses. My research has focused primarily on Intercept 1, largely at the police encounter itself. But in recent years, my research is shifting more and more to Intercept 0. I'll talk just a little bit about Intercepts 2 through 5, but all of these are important stages in criminal justice system processing in terms of options that we might advance to reduce entanglement and criminal justice involvement. By way of introduction, keep in mind that there are about 10 million arrests each year in the US. More than 80% of those are for low-level offenses, such as disorderly conduct, shoplifting, drug-related charges, etc., as opposed to violent felonies. Among people with serious mental illnesses, many charges are misdemeanors that are really related to quality of life crimes and public nuisance charges. These arrests and the incarcerations and other criminal legal entanglement that follows really interferes with treatment and recovery. So the police encounter is really the first step in criminal legal justice involvement. And according to the sequential intercept, this is at the initial encounter, this is where we might have the most impact. And so I'm going to be presenting two police-based initiatives that might serve as pre-arrest jail diversion among people with serious mental illnesses. Patrol officers out there on the beat often feel that they're serving as de facto mental health workers, having to make on-the-scene decisions, but really having too few options. As I'm going to point out, they can always make an arrest in nearly all situations because certain charges come with a lot of discretion for the police officer. They can make a transport to the ED or this crisis center under some circumstances if the individual, meets criteria according to state statute, or else they can do nothing. But doing nothing often is not really an option. And there are few other options for law enforcement officers. So that's sort of the big picture, the problem that my research is trying to address. I'm going to now walk through 4 different research pathways. One is really asking, well, what exactly do our patients get arrested for and why? The second is specifically about the CIT program, which is embedded within law enforcement agencies. Then I'll say just a little bit about a new form of community-based navigation that we developed in Southeast Georgia called Opening Doors to Recovery, because it too is relevant in terms of showing how a mental health service can reduce arrests. And then I'm going to explain what I call the linkage system and the research that's underway on that, also in Southeast Georgia and in the Atlanta area. So to start, research pathway 1, what do our patients actually get arrested for and why? I'm going to present 2 data sources. One comes from a clinical study and the other comes from a large-scale statewide study. So to start, I did a study in Savannah, which I'll briefly share with you later on, called Opening Doors to Recovery. We did a randomized controlled trial comparing opening doors to recovery as a form of community-based, recovery-oriented navigation to standard case management and intensive case management in Southeast Georgia. As part of that study, as patients were coming out of an inpatient unit and enrolling into my project, we happened to be able to get access to their rap sheets, their record of arrests and prosecution. They gave consent for us to collect that data from the state because arrest was one of our key outcomes. And so here we looked at just their lifetime history of arrest in the state of Georgia as they were coming into the study before they began participating in either Opening Doors to Recovery or case management. And I'm going to walk through some findings on the nature of their charges and arrests. So among 240 patients with serious mental illnesses, either a psychotic disorder or a mood disorder coming out of an inpatient unit, some 71% of them had been previously arrested, 71%. Among them, among that 171 patients, the total number of their lifetime charges was 708. The average number of arrests was 8.6. So not just one or two arrests over the course of their lifetime, but 8.6 arrests. The patients, by the way, were at a mean age of about 36, 37 or so. And within those average of 8.6 arrests, there were an average of 12.6 charges. This is a rank list of the most common charges from their rap sheets. We see that the number one most common charge is criminal trespass, a misdemeanor. The second most common charge is willful obstruction of a law enforcement officer, which I'll explain in detail, also a misdemeanor. Number 3 is disorderly conduct, a misdemeanor. Number 4 is shoplifting. Number 5 is probation violation, etc. And then we broke these charges into two separate rank lists. Among the patients who had been arrested at least 4 times, we looked at their first 2 lifetime charges and their most recent 2 charges. So the first 2 lifetime charges occurred right around the ages of 20 to 21 years old. And their most recent 2 charges was right around an average of 33 to 35 years old. So you can sort of think of this as, the first representing sort of a first episode age group, if you will, as compared to much later in the course of their illness, some 15 or so years later in the course of their illness. And we see changes in the rank list of their charges. Marijuana possession, for example, became much less common, whereas disorderly conduct became more common later in the course of the illness. We also see that willful obstruction of a law enforcement officer and related charges become more prevalent, higher on the rank list. And importantly, we see that missing appointments become common charges of common causes of misdemeanors. At their most recent 2 arrests, the number 1 most common charge is probation violation, which usually means missing an appointment with your probation officer. The 5th most common charge is failure to appear to court. Failure to appear to court, missing an appointment. We know that our patients with serious mental illnesses have difficulties keeping their appointments, whether it's primary care or the outpatient mental health clinic. And so it's not uncommon that they have a difficult time keeping their appointments with either their probation officer or with the judge. So our patients get arrested for mostly minor misdemeanors, often when arresting officers have a lot of discretion as well as for violations of the legal process, missing appointments. The types of charges and the processing of charges changes over time based on formal and informal policy changes within the criminal legal system, but probably also based on the evolving life circumstances and illness characteristics of our patients. So a second data source to try to understand what our patients most commonly get arrested for, we were able to look at all arrests in the state of New York from 2010 to 2013, some 2 million arrests in the state of New York during that time. And we were able to divide those arrests into occurring among people without a mental illness indicator versus arrests occurring in a person with a serious mental illness indicator, which means a Medicaid claims for serious mental illness. So there were more than 2 million arrests among those without the SMI indicator and more than 91,000 arrests among those with the serious mental illness indicator in the state of New York. And here we're looking at the UCR codes. These are the Uniform Crime Reporting Codes that states use to report to the federal government. And we see some differences in the percentages of arrests that involve these various UCR codes. For example, larceny or minor theft was more common among those with the serious mental illness indicator compared to those without the serious mental illness indicator. On the other hand, driving under the influence of alcohol was way less common among those with serious mental illnesses. Fraud was a bit more common. Simple assault was a bit less common among those with the serious mental illness indicator, but aggravated assault was more common as an arrest charge among those with the serious mental illness indicator. We also see differences like criminal mischief is a little more common among those with SMI, and having dangerous weapons is a little less common. Here are two ranked lists again. The top 13 charges among those without the serious mental illness indicator and among those with the serious mental illness indicator. The number one charge is petty larceny or shoplifting, but we do see some differences. Among those without the serious mental illness indicator, common charges include DUI-related charges. We don't see those appearing on the ranked list for those with the serious mental illness indicator, as well as possession of firearms or a weapon. But we do see criminal trespass creeping onto the ranked list among those with the serious mental illness indicator. So as part of our National Science Foundation funded project, we really decided based on those two analyses to settle in on these 5 types of misdemeanor charges. We then worked in 4 cities, Atlanta, Chicago, Philadelphia, and New York, to try to understand how these specific common misdemeanor charges are used and processed in the local criminal justice system. We did a series of system mapping exercises. We ran multiple focus groups involving many different types of criminal legal system professionals. And we compiled so much data that even after writing 4 or 5 articles, we still had more data that we wanted to write up and share. And so we put it into this book published recently by the APA called Entangled: How People with Serious Mental Illness Get Caught in Misdemeanor Systems. And in this book, part of what we do is we drill down and look at some very specific misdemeanors that our patients are commonly charged with, to share the history of those misdemeanors and the use of those misdemeanors from both a historical perspective and related to serious mental illness. I'm going to briefly walk through these 3 types of charges, but I would encourage you, if you're interested in learning more, to check out the book Entangled. So first, let's think a little bit about criminal trespass, which is, as we saw, a common charge among people with SMI. This is a state statute that really establishes a legal right for property owners to move people along, to exclude or banish people for violating rules of entry. So it's a legal tool for managing people's behaviors in spaces. Its use has declined somewhat in recent years as some cities and states have seen legal challenges to this charge because of its potential discriminatory policing practices, but it still remains in many jurisdictions a critical tool that the legal system uses to meet the demands of everyday people and business entities that desire to move people from spaces due to concerns stemming from standards of civility or business interests in attracting customers, etc. In many states, there are various caveats in the state statute that can escalate criminal trespass from a misdemeanor to a felony offense. As we detail in the book, criminal trespass as a type of charge really has a long and sordid history that goes back to the South's black codes that were used to govern the lives of newly freed black people, allowing the South to preserve systems of spatial segregation, social control, etc. But the charge did eventually travel north. In the civil rights era, criminal trespass laws played a prominent role in court cases involving lunch counter sit-ins and related stand-in type cases like Bowie versus the City of Columbia, South Carolina. I also want to mention that in many jurisdictions, because often the state statute related to criminal trespass says that it's the business owner that has to be present in order to lay the charge, that many jurisdictions have joined, the local businesses have joined up with the local police department and allowed the police department, police officers to be the person in charge of the property if the actual property owner is not present. This is a form of net widening, and it allows local police officers to actually lay the charge even if the person in charge or the business owner actually is not present. So it really gives law enforcement officers a lot of discretion in terms of being able to use this charge for someone who is not on their own property. The second misdemeanor charge that I'll briefly describe is very different. This is shoplifting. It's also known as petty larceny, retail theft. It's probably the most common offense committed in the United States. It accounts for a large share of what's called retail shrink. According to the National Retail Federation, there is a lot of money lost due to this retail shrink or due to shoplifting. States have different statutory definitions about the dollar value that distinguishes a misdemeanor shoplifting from a felony charge. States also have different caveats for upgrading the charge based on a person's prior history of shoplifting. There are also caveats related to whether or not a trespass notice has been issued. I would note that this charge might in some cases be directly linked to some psychiatric illness manifestations like substance use disorders, antisocial personality disorder, etc. It's more common among whites, yet consumer racial profiling exists. Officers' approach to shoplifting very much depends on what the store owner wants to do in a given scenario. And so here, compared to criminal trespass, the officer often has a bit less discretion. Now, and when we were doing our systems mapping, we found that in Georgia and in many other states, there are caveats that escalate a misdemeanor shoplifting to a felony. So imagine your patient 10 years ago stole this bag of chips and was charged with misdemeanor shoplifting. 5 years ago, stole this pair of socks and was charged with shoplifting. 2 years ago, stole this can of Diet Coke and was charged with shoplifting. And this year, stole a tube of toothpaste. In the state of Georgia and many other states, 3 strikes and you're out. This would become an automatic felony with at least a year in prison for the tube of toothpaste. So many of our patients don't know about these caveats in the law. Many people in general don't know, but this is an example of 3 strikes, you're out. The misdemeanor becomes an automatic felony. The third and final charge that I'll say a bit about is willful obstruction. This was a very, very common charge at some of our sites. All of us, no matter what our profession is, we're met with various frustrations by our clients. We're met with rudeness, refusals, obstructions, etc. But in one professional domain, this sort of bad behavior can be construed as a misdemeanor or even a felony punishable by fines, probation, and imprisonment. And that is when you're interfering with the professional duties of a law enforcement officer. It's called willful obstruction. It's closely related to other charges like resisting arrest, the charge of giving false information to an officer, not producing a state ID when asked for one, etc. Willful obstruction is also tangentially related to other types of charges like menacing and assault, as well as disorderly conduct. Now, some in our systems mapping exercises and focus groups, some defense attorneys told us that this is really what they view as so-called contempt of cop, the implication being that it can be a legally dubious charge based on an emotional reaction of an officer who feels challenged or slighted or whose authority is not respected. Very common charge. There's a long history of case law related to willful obstruction and this concept of fighting words and just how disagreeable do your words have to be in order to receive a misdemeanor or felony charge of willful obstruction. And I would point out that there are probably some specific features of SMI that could actually increase risk of either uncooperative behavior or what the police officer might view as uncooperative behavior, and thus likely increasing the prevalence of this charge among people with serious mental illnesses. So those are some of the charges that our patients receive and therefore are arrested for, go to jail, serve time for, ultimately go into probation, etc. So, that's the problem. We need a number of solutions to begin to really address this problem of criminalization. And I want to share with you now one approach, and that's the CIT program that is implemented in thousands of law enforcement agencies across the country. CIT originated in Memphis. It's also called the Memphis Model in 1988 after a fatal shooting of an African-American man with a mental illness by a Memphis police officer. So the Memphis Police Department thought, okay, we need to do something about this issue. NAMI Memphis got involved, the University of Memphis got involved, and the 3 of them came together, and that's the team in crisis intervention team. It's when you have these stakeholders, law enforcement, local mental health services, and NAMI or other advocates at the table to create a CIT program. There are 10 core elements of the CIT program. For example, having a single point of entry to emergency psychiatric care where law enforcement officers can drop off patients with easy access. That's one core element. Another core element is offering select law enforcement officers a 40-hour training so that they can learn more about mental illnesses and how to work with people with mental illnesses during their routine patrol duties. So back in 2004, I was doing first episode psychosis research at the time, and the newly established Georgia CIT program enlisted me as a researcher to help them study their implementation of CIT in both Atlanta and other jurisdictions in the state of Georgia. My colleague and I put together a book specifically for law enforcement officers and other public safety officials about how to respond to people with serious mental illnesses. And I spent a lot of time engaged in this CIT program. Here's a picture of a typical CIT class. It's usually about 20 officers that take part in a 40-hour, 1-week training delivered by both law enforcement trainers, but also multiple local mental health providers who are coming in and giving talks about psychosis, about mania, substance use disorders, etc. During this CIT training week, there's also a lot of role play practicing of de-escalation skills, verbal de-escalation skills. This is a typical CIT training week. Across the week, there are usually site visits to recovery centers where the officers can meet with and talk to people who have SMI who are in recovery and at their best, as opposed to a time when they encountered them at their worst. So I started doing some small, mostly unfunded research projects on CIT. One led to another, and at that time, I was really publishing a lot of small studies, focus group studies, other qualitative studies, surveys, etc., about crisis intervention team in Atlanta and in the state of Georgia. All of those studies led to getting an R01. This, I believe, was the first R01 that NIMH ever gave, focusing on police officers, not focusing at all on patients, but actually on police officers. We did this R01 study in 6 police departments in the state of Georgia. I'll briefly walk through some of the results. The first part of the study was we recruited 586 police officers from these 6 jurisdictions and brought them in small cohorts to basically complete a proctored 3-hour survey. So we collected lots and lots of data over the course of 3 hours in a small auditorium with 15 to 30 officers at a time, a total of 586 officers, 251 of whom had previously received the 40-hour CIT training, not just recently, though, at a median of 22 months prior to their assessment. And we looked at a number of constructs. I'll start here with knowledge about mental illnesses. The CIT officers, 251, outperformed the non-CIT officers in knowledge about mental illnesses. You see the p-value here. The effect size is respectable, given especially that their 40-hour training took place at a median of 22 months ago. A whole host of various types of attitudes about mental illnesses and their treatments. You see that all of these are significant. Some of the effect sizes are pretty substantial. We looked at self-efficacy for working with someone who's suicidal. We looked at stigma. We looked at their self-reported de-escalation skills, their self-reported referral decisions. We also, thankfully, asked the 251 officers as part of their survey if they had volunteered to go into CIT training or if they had been voluntold to go into CIT training. And so we were able to compare those two groups within the 251 CIT officers. And we did see some significant differences with higher scores among those who had volunteered to become CIT officers, which is one of the core elements of the Memphis model, that officers should self-select rather than just assigning officers to CIT or rather than just training the entire force. A number of significant differences. So the second part of this study, among those 586 officers, before they left the room, we said, hey, would you take part in another study where we'd like for you to carry around a notebook for 6 weeks and report an encounter form for every time you work with someone, you encounter someone who you think has a mental illness or substance use disorder or intellectual and developmental disability. At the end of that 6 weeks, we received 183 notebooks turned in with more than 1,000 encounters reported on. This is the front of the encounter form, demographics of the subject, observed or reported symptoms, how long they were on the scene, etc. This is the back of the encounter form, the level of resistance of the subject, and all of the various techniques or equipment used, as well as the disposition. And here we did report that among these encounters, as reported by the police officers participating, the CIT officers were less likely to make an arrest, and they were more likely to refer or transport to mental health services. We looked at several different models to understand how CIT training works, including the theory of planned behavior, published quite a bit of research on CIT, and really, my dear colleague, Amy Watson, and I have come to believe, she's done a lot of research on CIT as well in both Chicago, primarily in Chicago, although she's now at Wayne State in Detroit. We really have come to the conclusion that CIT can be designated as an evidence-based practice for law enforcement agencies to implement with regard to officer-level cognitive and attitudinal outcomes. But we need more research on other types of outcomes. And in this article, we lay that out in terms of what the next steps for research need to be. She had an R01 on CIT in Chicago. We've collaborated on each other's R01s, and now together we have an R01 that we are co-principal investigators, where we're doing a full-on randomized controlled trial of CIT training for police officers. We've enrolled 242 officers across 7 sites. We're almost finished with our longitudinal data set. So have me back next year and I'll be happy to share the results with you. Our main approach to testing is where we send officers through 3 scenarios. One with someone with psychosis and agitation, another scenario with someone who's depressed and suicidal, another scenario with someone who has mania and is refusing to leave. We video record 5-minute interactions with those 3 scenarios, which you might be wondering are played by professional actors, sort of standardized patients, if you will, that we fly along with our research team to these various sites longitudinally. Those videos are going to be rated by trained raters who are blinded to CIT versus non-CIT status, blinded to the site, and blinded to the time point. These are our 7 sites. We allocated 121 to go into their local CIT training. 121 did not. That's the control group. And again, our results should be ready within about a year. This is our protocol paper. Also, sort of publishing on our methods as we go along. I want to just very briefly say a word about a mental health intervention that can reduce the risk of arrest. We developed this in Georgia. It's called Opening Doors to Recovery. And it's really where there are 3 community navigators that work together in a case management fashion, but really in a community navigation fashion. The 3 case managers are a professional CNS, community navigation specialist, who's a social worker, a peer navigator, and a family navigator who's a family member of someone with a serious mental illness. We developed this model, we did some research on it, and then we were able to get an R01 to do a randomized controlled trial. And I'll only present one result, and that is that in the 12 months of working with the ODR team, the proportion of patients arrested was 21% compared to the patients receiving traditional case management who had an arrest rate of nearly 40% over the course of 12 months. So this is an example of how a well-designed mental health approach can actually reduce arrests if the focus is on that specific outcome. And I'll briefly now present another intervention that we've developed. It's actually one ingredient of the opening doors to recovery model that I pulled out and wanted to study separately as a separate intervention. It's called the linkage system, and let me explain how it works. It's the subject of an ongoing randomized controlled trial involving 1,400 outpatients with SMI in both Atlanta and Savannah. So the way the linkage system works is, I'm sure that some of you have at some point been pulled over by a police officer. And what happens is he or she always takes your license and goes back to the car and sits in his car for 5 minutes while you're sweating bullets, wondering if he's going to give you a traffic violation or just a warning. What's he doing in his car during that 5 minutes? He's actually entering your driver's license information, name, date of birth, driver's license number, eye color, hair color, etc., height, etc., into his laptop, in his car. That demographic information is being queried against a database held at the state that is a database with everyone who has a warrant for an arrest, a bench warrant. If there's a match, then the officer knows that you actually have a warrant out for your arrest. If there's not a match, then he knows that you don't have a warrant out for your arrest. But there's not just one database, there's another database indicating whether or not you're on probation, another database indicating whether or not you're under protective orders, another database indicating whether or not you're a sex offender, etc. So the officer is entering your information, which is querying these state databases to determine if you meet any of these criteria, if you will. So the linkage system is where we worked with the state of Georgia to create yet another database. And that is where the officer would receive a notice if there's a match that you are in a special mental health program. Please call this phone number. The officer is then able to call the clinic where you're in treatment, and there's a temporary pull down of HIPAA, and the officer can have a conversation with the social worker at the clinic where you're in treatment, get a little information, and hopefully in a few instances, when an arrest is at his discretion, there might be we might be able to prevent an arrest for a low-level misdemeanor. So we started with an R34. We looked at acceptability among patients, among police officers. We did an initial feasibility study in the R34 with 200 patients with serious mental illnesses. They were in the linkage system for 12 months. Comparing their prior 12 months with their 12 months of being in the linkage system, we saw a very, very small decrease, what appeared to be a decrease in the number of arrests. This is the effect size. It's only 0.13 in this R34, but that was the number that we needed to power up the randomized control trial, which we did with 1,400 patients. We now have their rap sheets, and we're about to analyze the data. So I'll just very briefly mention some current interests. Dr. Watson, Dr. Pope, and I, we do almost all of our research together, and now we're really interested in shifting more and more of our focus from Intercept 1 back to Intercept 0. We're really, we're studying crisis, we're studying 988, the crisis continuum, to really hopefully shift more of this, not only crisis response, but our work to Intercept 0. As you all might know, there's a lot going on over the past 10 years at CMS and at SAMHSA, building up the crisis response system. We just completed a project funded by the Pew Charitable Trusts, where we looked at a national landscape. We looked at all 50 states and how they've utilized these various federal funding mechanisms over the past 10 years to really improve and expand crisis services that do not involve law enforcement officers, like mobile crisis teams, for example. So that work is coming out soon. We're also really interested in workforce, especially mobile crisis team workforce and the workforce related to other types of alternative responses that do not involve law enforcement officers. We're thinking through, how would we develop a new discipline? A discipline that we call community behavioral health crisis responders, sort of similar to EMTs, but on the psychiatric side. We're working to lay out what that discipline would need to look like so that we can fully staff up mobile crisis teams and other types of non-law enforcement crisis response. And we're also working with the Sozosay Foundation. We just established what we call the Sozosay Lab for decriminalizing mental illness, and we're going to be bringing in early career fellows to do small research projects to really hopefully kick off their research career in this area of criminal justice entanglement among people with SMI. And I'll end by saying the other intercepts are also very important. As I mentioned earlier, failure to appear to court is a big problem. I'm hoping to get into this area, working with prosecutors, working with judges, so that we can figure out how can we help our patients with SMI not have bench warrants and ultimately arrests and incarcerations just for missing an appointment, either in the court or with their probation officer. I will stop there, and I'm very happy to hear any thoughts that you all might have or any questions that you might have. Thank you.
Yeah, we've got about 8 minutes left for Q&A. So folks at home, go ahead and type those into the Q&A. It looks like we've got one that came up already. So let me go ahead and read this, if I can. Okay, 3 related questions. All right, just to start. Did ODR study participants have much hesitation in sharing rap sheets or other sensitive information with researchers? How did the ODR temporary pull down of HIPAA work legally? Are there validated predictive tools to identify people for proactive interventions at intercept 0? And if these are lacking, what other data signals may be most salient? So utilization, clinical variables, complexity of SMI, SUD, SDOH intersection.
Thank you for that. So it's a good question about rap sheets. Actually, no, there were very, very few potential study participants who did not want to participate because we would be pulling their rap sheets. They, through, a very detailed consent form, they understood what we were studying when we wanted to compare ODR with traditional case management. We were looking at hospitalization rates. We were looking at arrest rates. We were looking at homelessness rates, and we knew that self-report of arrests would have major limitations, and we would have a lot of missing data when clients, for example, dropped out of the intervention or dropped out of the study. The rap sheets are pretty much 100% valid. It's the full data in the state of Georgia. Now, if they were arrested across the bridge in the state of South Carolina, we wouldn't have that. So the numbers that I presented and the charges that I presented are probably a bit underestimated. But the bottom line is, no, they didn't really seem to mind that we were collecting their rap sheets because they were confident in terms of how we were going to handle that sensitive data. The temporary pull down of HIPAA, that's because they signed a detailed consent form to allow the police officer to not only receive a notice that the person has a mental health condition, but also to go ahead and call the linkage specialist in the clinic. They consented to that. And they wanted that temporary pull down of HIPAA. When, you know, a person with SMI is facing a potential arrest, they want the officer to know what's going on with them. That's what we found in a lot of focus groups and a lot of conversations. And so they didn't mind if the officer was able to call the clinic and have a quick, usually 1 to 2 minute conversation with the social worker. We don't know for sure if the linkage system has any effect on reducing arrest. We'll know soon. But our hypothesis is that that very brief conversation might, in some very rare instances, be able to avert an arrest. And then the third part of the question, I don't know about validated predictive tools to identify which intercept zero interventions are the best, but I would say that we need the full continuum of outpatient mental health services available in any given community to really bolster Intercept Zero. That's what Intercept Zero is. It's a strong community mental health system with all of the various levels of care within that outpatient system. It's only when that is as strong as we can make it that we have the best chance of reducing arrests and decriminalizing, because people will be engaged in treatment, less symptomatic, facing fewer psychosocial circumstances that put them in the wrong place at the wrong time, and therefore, you know, encountering law enforcement officers.
All right, thank you for that answer. And I'll follow up with the next question here, which is someone who just wants to kind of have some of the terms defined. So what exactly is the SOSE Foundation, the R01, R34, those terms like that aren't familiar to everybody.
Sure, and I apologize for that. So the NIMH, which funds a lot of our, you know, large scale research on mental illnesses, has a number of different grant mechanisms that we can, as researchers, apply for, depending on the nature of the proposed study. And R34 is an intervention development grant. And so for the linkage system, we started with an R34 to really develop the intervention, test acceptability, test feasibility, and then that led to what's called an R01, which is a formal, large-scale, 4 to 5 year research project like a randomized controlled trial. And also, thank you for asking about the SOSE Foundation. This is a relatively young foundation that's focused specifically on decriminalizing serious mental illness. And so they fund community programs, research projects, and other avenues to really try to address this very specific problem of decriminalizing.
Okay, great. And while we're waiting to see if anybody else has any questions, I will address this first one, which is just someone asked about if this is going to be recorded and available. And the answer is yes, we've recorded it. We have an archive that you can access through our department's website. And also, if you received the email about this presentation, there's a link to the archive in there as well. Okay, we have a couple minutes. I guess I'll ask, I have one question that I'm curious about that might be outside your scope, but when you talked about having actors helping as part of the training, I was just curious about what are the actors themselves trained in how to portray SMI patients? How does that work?
Yes, it's been a really, really fun and fascinating project. We've taken now, we go back to one of our sites next week, but we've taken 20 trips to these 7 sites across the country with 4 of us on the research team plus 3 professional actors. And they're professional actors. We enrolled the help of a director and actor himself, who's a psychologist, to help us figure out how to hire and work with professional actors. So we had a whole a call. We had initial auditions. Then we had callbacks at Columbia in an auditorium. Then we selected our actors after they performed, mania or psychosis. And then we got them together. There were 9 total that we hired as consultants. We trained them over the course of 2 days. And then we've done a number of things to make sure that they're highly standardized in terms of how they portray psychosis, depression, and mania. And they really are sort of a standardized patient that allow us to have a very, very controlled stimulus that the officer is exposed to, and while we're recording their interaction. It's been a lot of fun to work with the actors.
Yeah, thank you. I'm glad I had a chance to ask that question. That's interesting to hear about. So it's really cool. Well, it looks like we've gotten, oh, no. Sorry, we have one more question. I do want to get to this last one before we close it out here. So this person is curious to hear about your thoughts on standardization of policy regarding police departments sending police reports of individuals with known SMI, the history of violence and or criminal records such as violent felony to local mental health crisis response team. So here where this person lives, they're told that their local police department, that it's my job as a caretaker to acquire the reports and send it to the local CRT, which this person finds absurd.
Yeah, this is an interesting area related to information sharing between the criminal justice sector and the mental health sector. Obviously, the information can flow much more easily in one direction than the other. And I don't know a lot about how local jurisdictions are sharing this information from criminal justice over to mental health. But I do know that in some jurisdictions, when a person with SMI is arrested and booked, that they are able to generate a report over to the mental health system so that at least the mental health provider knows that my patient is now booked in jail and is likely to miss his appointment, et cetera, so that there can be a more immediate connection between, the local jail and the local mental health system. So there is some of that information sharing. I think it's very, very local in terms of exactly how it works. And I don't know of any actual models in place to really inform jurisdictions around this.
All right, great. Well, thank you very much. We're gonna, I think, wrap it up here. We're a little after 1 o'clock. So Dr. Compton, thank you so much for being here today, sharing this with us. Really informative. Thank you.
Thank you. Take care, everyone. Thank
Yeah.
you.